that brings us to the final part of our conference, which is our closing keynote. And we have Professor David Engstrom here, who's, of course, the director of our Center for the Legal Profession here. He's also an affiliated faculty with Codex, a leading expert in law and technology, but also administrative law and Civ Pro, thinking a lot about access to justice and how the court system needs to be reformed, running lots of projects on that topic, some of which we may learn about in a little bit. And David is, I think he's also a graduate of this wonderful law school. I think he also has a master's from Oxford and a PhD from Yale. But anyways, without further ado, I'll turn it over to David Engstrom. All right, please join me in welcoming him.
All right, thanks, Roland. Thanks to you, of course, and to the rest of the Codex crew for giving me the privilege of closing out this really extraordinary conference. I love FutureLaw. I love it every year, and this year's version has frankly felt even more alive to me than usual, and perhaps that's because this is the first year that we've all had a little bit of time to take the measure of generative AI. But it's also the case that the legal tech landscape remains studded with really difficult questions. Some of them are new, some of them are a spin on the old. And so today I'm just going to try to close out what I think was a great day by working through with you all what I see as the three most important questions, all drawn from my work here at Stanford and out in the world, that I think are going to define legal tech's future and with it the next chapter of the civil justice system. So one of the questions you're going to see goes to the distributive implications of generative AI. Another goes to the regulatory constraints we might use to corral or cabin it. And a third goes to how exactly it is that courts are going to try to drag themselves into the 21st century technologically. Here's the first question. It's that distributive one, which is, will generative AI level or slant the litigation playing field? Law professors like me have been talking about this for years. Right back in the early days of AI, back when legal tech was mostly e-discovery and tar, we started a battle. We started asking, whether new technologies would democratize legal services, whether they would allow 1, 2, or 3 lawyer shops to do battle with big law firms. But we also fretted about whether one side should be able to compel the other side to share its seed set and check its work, even though that seed set contains documents that aren't relevant, and even though that seed set might be protected work product. That's the civil procedure professor and me coming out. But more generally, we worried a bunch about whether more sophisticated litigants would be able to engage in discovery fraud in ways that less sophisticated adversaries could not detect. And on this view, like the sweeping in of machine learning into the system, seems to like it might propel the haves further ahead within the civil justice system. But boy, that feels like so long ago, because it turns out that tar was really just the canary in the coal mine. And I think those early debates feel really quaint in a world of generative AI and RAG and a growing suite of tools that perform ever more sophisticated legal cognitions. One thing, though, has remained constant amidst all these various leaps in AI, and here it is. Whether or not analytics are evenly distributed across the legal system, the haves of the litigation world, especially the repeat players within the system, will often have privileged access to data. And this really, really matters. And it matters in particular because the holy grail of legal tech is case outcomes, At least in terms of data, it's case outcomes. But lawyers know that most cases in the American legal system, they exit dockets via curt voluntary dismissals, the result of settlements, or are cloaked by NDAs and secret settlements. The result is that only the big entities and the repeat players have access to the case outcome data that is necessary to power truly potent legal tech tools. And indeed, if you go back just a few years, it was Walmart, the ultimate repeat player within the civil justice system, who was first out of the blocks with legal tech tools that could predict case outcomes, and just as important, how long it would take and how much it would cost to achieve those outcomes. That said, in a world of generative AI, I think the lack of public access to law may be an even bigger concern in the part of the legal system where courts are moving an endless parade of debt cases, eviction cases, and family law matters. Most of you in the audience know about that part of the system, even if you don't actively work in it. It's the part of the system where in something like 75% of the 20 million filed civil cases each year, at least one side lacks a lawyer. And it's also why currently, amazingly, stunningly, the modal case in the American legal system right now is a debt collection action with a bank, a credit card company, a debt buyer, or a corporate landlord with a lawyer on one side and an unrepresented individual in the other. In that part of the system, there's already worrying evidence, including a recent paper from Dan Ho, who kicked things off this morning, that generative AI, while performing quite well on big national scope cases, so think the United States Supreme Court, does less well and hallucinates more often in localized contexts, so think housing courts. It's also where the lack of public access to law is most acute and will plainly limit the utility of open source models going forward. Ensuring equal access to law is going to be critical to the proliferation of accurate, domain-specific generative AI tools. So here then is a towering challenge that I think is going to shape legal tech's future at all levels of the system. As I and many others have argued in recent years, AI fueled legal tech's trajectory, and in particular, the amount of time that people in this room spend on tools that augment the legal capacities of the haves of the system, as opposed to the have-nots of the system, will turn in significant part on how policymakers, rulemakers, and the courts themselves control the flow of data into the system, and in particular, the terms on which they make data available to the outside world. And with the advent of generative AI, that observation just seems more true than ever to me. That's the first question. You ready for the second? All right, here's the second. It's where will regulatory reform, the movement to relax the usual rules that say that only lawyers can practice law and own law firms, where will that land? Those rules, as you know well, prop up the lawyer's monopoly. And as Gillian Hadfield has noted, including right here at FutureLaw a ways back, but she was here, those rules have operated to cut law off from the sources of innovation that have remade much of the rest of the economy. So 5, indeed even 2 years ago, I thought regulatory reform, the relaxation of these rules to permit new types of legal services providers into the system, I thought it was inevitable. There was the Utah sandbox, there was the Arizona ABS system, and the early returns from those two places, something I wrote about in a report that my center put out, showed some really impressive examples of legal innovation. Many other states were starting to consider similar reforms, and reg reform, though I think we can all agree is a dreadful piece of political sloganeering, could only be thought up by lawyers, I think, was becoming a movement. Adding to the momentum was really interesting First Amendment litigation challenges to state UPL rules in places like New York and South Carolina and North Carolina. And that case is currently parked in front of the Second Circuit in New York, but the plaintiffs got an injunction against the Attorney General of New York against enforcing the state's UPL rules. But I have to say the counter reaction has been really strong. So here in California, I served as an appointee to the state bar group that was tasked with making a sandbox recommendation to the California State Bar and to the state legislature and to the California Supreme Court. And after a year and a half of work, that effort was unceremoniously shut down by the judiciary chairs in the California legislature. Afterward, I wrote a very intemperate slate piece about it, but the damage had been done. Here's some other problems with reg reform. What about the really worrying empirical papers showing private equity's effects on healthcare quality? That's not helping the reg reform debate at the moment. But the biggest concern of all, and what I predict will be the biggest source of political headwinds within the reg reform movement, is something that's new to the generative AI world. And here's what it is. It's what the National Center on State Courts recently called the sea of junk. Generative AI is already shifting the entire legal services marketplace in a DIY direction. Gemini, Claude, Bing, ChatGPT have brought something that looks an awful lot like legal advice within reach of ordinary Americans, and it's basically free. Margaret Hagan, where are you, Margaret? There you are. She's leading the way in thinking about all of this and the implications of all of this, and it's frankly pretty grim. The American legal system will soon be awash in legal information, even advice. Some of it will be quite good. Much of it will be quite bad. The sea of junk. How will regulators respond? That's the question. It's increasingly easy for me to imagine states outright prohibiting OpenAI from doing legal. I think it's also possible that courts will do something they've been talking about for some time, which is a kind of court-overseen certification process to decide which legal tech providers get to be EFSPs, right, e-filing service providers, and thus can connect to the courts and give their customers all-important access to e-filing. Whether either of those things happen, it's clear that the sea of junk is going to put new hurdles in the way of regulatory reform. And that's a policy concern that everyone in this room should be thinking about. It might just drive a stake through the heart of efforts to empower new types of legal services providers within the system, especially software-driven ones. That should be of premier importance here at FutureLaw. All right, here's the third question. As courts drag themselves into the 20th century technologically, will they, and more importantly, should they, make, buy, or partner? What do I mean by that? I have long been arguing that courts face a basic make or buy choice when it comes to technology, with really important implications for the future of legal tech. Courts can make by building their own suite of digital pathways and self-help services, from chatbots to fully integrated form filling and filing to ODR. Alternatively, courts can, in effect, buy the services of third-party legal tech providers out in the world by improving accessibility and connectivity, for instance, through APIs, and by taking other measures, such as lowering e-filing barriers, in order to foster a robust ecosystem of providers out in the world who can serve different segments of the market. That should be music to the ears of FutureLaw attendees. But I've also been arguing that the choice is a difficult one and it's a not obvious one. And in fact, the two options require very different tech infrastructures, and it's not at all clear that courts can do one of them, given their current resource allotments, let alone both. There are also really hard questions, as I just noted, about which one of these is the right path for courts if what we want is a healthy civil justice system. And so we've placed those questions front and center in the work we're doing here at Stanford via a project called the Filing Fairness Project, which I co-founded with Margaret and also Mark Chandler, who's the former GC of Cisco. So we've been working a lot on BI, but BI, of course, has lots of problems, and we've really been struggling through them with our state partners. There's those restrictive rules, UPL and 5.4, which limits what the folks you're buying out in the world can do for you. A more significant barrier may be that when you look across the roughly 14,000 local court jurisdictions in the United States, you see a checkerboard of technology and data infrastructures, not to mention variations in substantive and procedural law. And this defeats the scale that legal tech providers need, right, to build a business model serving customers who by definition have a limited ability to pay. But Make brings challenges too. The most obvious one is that court technical capacity remains shockingly thin. Courts are woefully lacking in IT expertise, let alone AI. Here's where partner comes in, and I think it's a key change to the court tech landscape as a result of generative AI. The coming of generative AI means that many of the AI-based research analysis, simplification, wayfinding tools that courts might develop for direct-to-consumer use will need to be built on top of one of the foundational open-source LLMs. From there, as courts seek to improve the accuracy of these models, lots of in-house work is going to need to be done, customizing and building additional sources of truth into the tools. As a result, partnering is going to be necessary in the age of generative AI, but partnering only partially solves the problem of limited court technical capacity. So here at Stanford, we're going to try to test out some of the possibilities around Make. And we're going to do it as part of a new collaboration with the LA Superior Court that was announced. I guess the court announced it back in January, and this is again something that Margaret and I are currently working on. We're still in the early stages, but our hope is that by combining Stanford's extraordinary technical talents, perhaps also working with some partners in this room, we can seize an unprecedented opportunity to build, implement, and rigorously test a new court-hosted end-to-end digital pathway with a generative AI component in the nation's largest trial court. And that would be huge. That could become the first real effort to validate a generative AI model in a court in the wild. It will also allow us to study a no less difficult challenge, which is how do you institutionalize new AI tools in complex bureaucracies, which is what a court is. Right? We know lots about how to do that in the healthcare context, in hospitals. Legal, not so much. But here's what I like best about Make, and it's what excites me most about our work with LA Superior. By working with courts directly, I can see a path to a world in which we don't just try to fold LLMs into the existing system, right, with all of its antiquated assumptions about adversarial process, but rather we try to more fully rethink what that system can and should look like if and when LLMs are good enough, at least for some matters, to play the role of judge or lawyer. That could mean an ODR system that people actually use. No one uses ODR systems that are currently implemented in courts. Or it could mean an entirely new approach to adjudicating particular types of cases. Remaking the system might start with a kind of Make digital courthouse front door, but it can then lay the foundation for more radical efforts to redefine the role of law and its architecture. All right, let me leave off with this. So Natalie Knowlton, is she out there somewhere? Maybe not. Maybe she's not here today. She helped me to see what I think unifies all three of my questions. And it's a core concern, which is that our current civil justice system, especially its digital components, is rife with monopolies. And that maybe shouldn't be surprising. Remember that book, The Master Switch by Tim Wu? Again, it feels quaint. It feels like so long ago because it was, before the AI era. But he described a cycle in transformative information technologies that he then traced through film, radio, telephone, television, and the internet. And here's what he wrote. Bear with me. He says, history shows a typical progression of information technologies from somebody's hobby to somebody's industry, from jury-rigged contraption to slick production marvel, from a freely accessible channel to one strictly controlled by a single corporation or cartel, from open to closed system. History also shows that whatever has been closed too long is ripe for ingenuity's assault. In time, a closed industry can be opened anew, giving way to all sorts of technical possibilities and expressive uses for the medium before the effort to close the system likewise begins again. That might perfectly describe where we are currently at across the three questions as generative AI is sweeping into the legal system. There's the monopoly of big legal tech, big law, and courts over the data inputs necessary to drive potent legal tech tools. There's the lawyer's monopoly on legal advice. There's big tech's monopoly on foundational generative AI models. And overhanging all of this is the court's monopoly on state-sanctioned dispute resolution. And so at the end of the day, and at the end of this really terrific conference, the basic question that remains is in some ways just really simple. Staring into a crystal ball and into our ideal future, which of these monopolies will stay and which will go? And which of these monopolies should stay and which of these monopolies should go? So I look forward to engaging with you all on that question and the three related questions that I worked through today, starting with a drink right now out in the courtyard in the sunshine, and in the months to come as we all work toward legal tech's future. So thanks again to Roland and everyone else at Codex for the opportunity to be here today.
All right, well, that's it. That's a wrap. Thank you, David Engstrom, for this wonderful closing to our conference. It's been a long day. I think what David presented, I think, gives us a lot of food for thought and excitement about the work that's going on, and also open questions that we need to address. And I think it's an open invitation from David to this community to work with him and others here at Stanford to try to tackle some of these challenges. And David, thank you for staying around at the reception, and I'm sure folks will have some follow-up questions. We're actually closing on time, which is amazing. And yeah, I just want to give a quick shout out to Megan, my associate director, and for all the great work. And Harry Surden, our other associate director and center co-founder. He's no surprise, he's already at the bar, so you can't hear me. But anyways, and thank you all for everything you brought to this conference, for all your great questions, for spending your time here, and really look forward to mingling with you outside. And thank you all again. It was a wonderful day.